All right, chapter 3, medical and medical, legal, and ethical issues. All right. Now, for this chapter, we'll be looking at consent, refusal of cure, confidentiality, advance directives, tort and criminal actions, evidence preservation, statutory responsibilities. We'll be looking at the importance of mandatory reporting, ethical principles, moral obligations, end-of-life issues. Introduction. A basic principle of emergency care is to do no further harm. Litigation against EMS will likely increase due to wider availability and more complex care. Providing competent emergency care that conforms to the standard of care will help avoid civil and criminal actions. So, working within your scope of practice and adhering to the standard of care and staying up to date and current with your certification and registration is what is going to reduce the possibility of civil and criminal actions. Also consider ethical issues. Even when emergency medical care is properly rendered, there are times when you may be sued. Administrative action may be brought against you if you do not follow EMS regulations. Scope of practice outlines the care you are able to provide, usually defined by state law. Medical director further defines by developing protocols and standing order. So your scope of practice is all the skills that you are allowed to perform at your level. And the medical director can limit your scope of practice, but the medical director cannot expand the scope of practice. So medical director authorizes care via telephone/radio, standing orders, or protocol. So either by offline or online medical direction. Carrying out procedures outside of the scope of practice may be considered negligence or a criminal offense if a law is broken. The scope of practice is different from the standard of care. So again, scope of practice are all the skills that you are allowed to perform at your level of training. The standard of care is how you execute the skills, how you perform these specific skills. Must be at the required standard of care. You have a legal responsibility to provide proper, consistent care and report problems. Again, consistency, consistent. You see how often that word keep popping up? Consistency. Standards of care, the manner in which you are required to act or behave. You must be concerned about the safety and welfare of others when your behavior has the potential to cause harm. The standard of care established by published medical research. So the standard of care is based on research, local custom, or a person with similar training and experience would act under similar circumstances. Law, statutes, ordinances, administrative regulations, case law, emergency medical treatment, and active labor act. All of these components help to establish the standard of care. Professional and institutional standards. Example, AHA, CPR standard, and state regulatory agencies. So you have standards for the profession. I have institutional standards, which cover how you will execute certain procedures in the field. Standards imposed by textbook, EMS enabling legislation, standards imposed by states, Medical Practice Act, your certification and licensure. Negligence, failure to provide the same care that person with similar training would provide. Gross negligence, conduct that constitute willful or reckless disregard for duty. Three categories. It can be malfeasance, which is think of it as malpractice or bad practice. So you perform a particular task in an incorrect way. Or it can be nonfeasance. You fail to perform a task that was necessary. Res ispa loquitur, the thing speaks for itself. Negligence per se, it's obvious. All four of the following elements must be present for negligence to apply. So you must have a duty to act. There must be a breach of that duty. And also note that if your certification is outdated or you're not current, that's a breach of duty. There must be damages incurred to the patient, and there must be causation. So there must be proof that your breach of duty is what resulted in the damages. Abandonment, termination of care by the AEMT without the patient's consent when patient has continuing need for medical care. Once care is started, you have assumed a duty that must not stop until an equally competent person with equal or higher training assumes responsibility. A legally and ethically serious matter that can result in civil or criminal liability. So abandonment is very serious. Abandonment may take place at scene or in the emergency department. Assault and battery. Assault is threatening or causing a person to fear, causing a person fear of immediate bodily harm without consent. Battery is unlawfully touching a person, and it includes providing care without consent. Can be civil or criminal in nature. Kidnapping and false imprisonment. Kidnapping, seizing, confining, abducting, or carrying away by force, not common in EMS. False imprisonment is more likely. False imprisonment is unauthorized confinement of a person. Defamation, slander, and libel. Defamation, intentionally making a false statement through written or verbal communication that injures a person's good name or reputation. Libel is making a false statement in a written form. And slander is making a false verbal statement. Good Samaritan laws and immunity. If you reasonably help another person, you will not be held liable for errors or omissions made in giving good faith emergency care. However, the Good Samaritan law does not apply if you're on duty. So if you're on duty, the Good Samaritan law will not protect you. So these laws do not protect you from a lawsuit. They vary from state to state. The Good Samaritan law is applicable if you're off duty and you come upon a scene and decide to assist someone. It does not apply when you have a duty to act. Another group of laws grants immunity from liability to official providers. They do not provide immunity from gross negligence or willful misconduct. Sovereign immunity identifies limited types of lawsuits that can be filed against a government agencies. So there is a specific time in which the lawsuit need to be filed, and if it's not filed within that specific time, then it can go to court after a certain amount of years. Laws vary. Always consult with medical director. Consent. Consent, this is permission for treatment, required for every conscious, mentally competent adult before cure can be started. If the patient is alert, rational, and capable of making informed decisions, he or she has a legal right to refuse cure. It requires decision-making capacity, the ability of a patient to understand the information you are providing and process that information. Talk to the patient to find out if the patient understands what is happening to him or her. Express consent. The patient acknowledges that he or she wants you to provide care or transport. It may be verbal or nonverbal. Patient must provide informed consent. Describe the suspected illness, injury, the treatment you would like to administer, and the potential risk if the patient should refuse. Advise the patient of the consequences of refusing treatment. To provide informed consent, a patient must be of the legal age, and they must be able to make a rational decision. A patient may agree to certain emergency care, but not other care, and it is their right to refuse. Implied consent, this is appropriate when the patient is unresponsive, delusional, showing signs of an altered mental status, otherwise incapable of making an informed decision. It is limited to true emergency situation. It may become a legal question, so document all actions thoroughly. Try to get consent from a spouse or relative if possible. Refusal of cure may also be implied. Implied consent no longer applies if patient regains consciousness and appears capable. So if the patient regains consciousness, you need their permission to continue treatment. Minors and consent. Parent of legal guardian gives consent. In some states, a minor can give consent depending on age and maturity, whether they are married, pregnant, or emancipated minors, meaning they're taking care of themselves or living on their own. Minor parents can give consent for their children. Obtain consent whenever possible in loco parentis, always in non-life-threatening situations. If true emergency exists and no consent is available, treat the patient. Consent is implied. Involuntary consent. It's an oxymoron because consent can never be involuntary. People under arrest or in prison do not necessarily lose their right to be involved in medical treatment decisions. If a prisoner refuses treatment, involve medical control. Forcible restraint. This is the act of subduing a patient to prevent harm. Applies to patients who are physically violent, present a risk to you or your crew members or family members or bystanders in need of specific treatment. Legally permissible If you believe the patient is a threat to themselves or others, you can restrain them. Consult medical control for authorization. Restraint without authority exposes you to civil and criminal penalties. If the patient is responsive and the situation is not urgent, consent is required. The right to refuse treatment. Any patient that is conscious and alert and is able to make sensible or firm decision, meaning they understand the gravity of the situation, they understand the risk involved, that patient has the right to refuse care. They can withdraw from treatment at any time, even if the result is death or serious injury. These patients present the AEMT with a dilemma. Commonly litigated, proceed cautiously. So these are the focal point of a lot of litigations in EMS. Patients refusing care and then something serious happen after. You can be held liable. Make sure the patient understands potential risk, benefits, treatments, and alternatives. In order to refuse treatment, the patient must be alert. They must be oriented to person, place, time, and event in that order. When in doubt, proceed. Urge patients to seek further medical evaluation from a physician. State laws generally do not permit a parent or legal guardian to deny treatment for a minor. Consider the emotional impact of the emergency. If you are unable to obtain consent, document any assessment findings and care. Note how much time you spent attempting to provide care. The report and patient signature should be witnessed. Know what to do if the patient refuses to sign the release form. You'll be guided by your protocols or medical direction. Advanced directives. Specify treatment if patient becomes unable to make decisions. So living wills. Do not resuscitate orders, organ donation orders. So these are our advanced directives. DNR order gives permission not to attempt resuscitation. It does not give permission not to treat. To be valid, it must state the patient's medical problem, should have a signature for the patient or a guardian, and it should have a physician signature. It can have more than one physician signature on it. I have different types of DNRs. Even with DNR, you must provide supportive measures. Patients may have healthcare proxies, durable powers of attorney for healthcare. Only apply if the patient is not capable of making decisions. So a healthcare proxy is someone else who can make decisions on the patient's behalf. Read carefully. Ethical principles and moral obligations. Ethics, philosophy of right and wrong. That's what ethics is, the philosophy of right and wrong. Moral duties, ideal professional behavior. Morality, code of conduct affecting character, conduct, and conscience. Applied ethics, manner in which ethical principles are incorporated into professional conduct. And this is extremely important to your profession as an AEMT. You're in the medical field, you're going to be dealing with patients. Ethics, ethical principles, and moral obligation is extremely important. Excuse me for a sec. All right, sorry about that. I'm back. You must meet your legal and ethical responsibilities. while caring for your patient's physical and emotional needs, right? Practice absolute honesty in reporting, right? So your report need to be properly written. Don't put any false information in your report. Don't make up any findings. Don't put in your report that you did anything that you didn't do. Keep your reports accurate, maintain a mastery of skills, and have a standard format for your reporting. And usually your organization will determine what that format will be, whether it's a chronological approach, SOAP method, chart method. AEMTs will encounter ethical dilemmas. Failure to live up to legal or ethical standards can result in criminal or civil charges. Confidentiality. Communications with patients is confidential. Confidential information includes assessment findings, treatment provided, diagnosis, mental and physical condition. If you release information, you may be liable for breach of confidentiality. General records may be released only if the patient signs a release, if legal subpoena is presented, sharing info with third-party billing, to health agencies concerning diseases that may affect the population, events such as seizure activity that may be reported to the Department of Motor Vehicles, cases of rape or abuse. Improper release of confidential information or release of inaccurate information can result in liability, may also result in charges of libel or slander. Document only objective findings, not personal opinions. Health Insurance, Portability, and Accountability Act, HIPAA, contains a section on patient privacy that strengthens private laws, safeguard patient confidentiality, provide guidance on what information is protected, responsibilities regarding that protection, penalties for breaching that protection. All patient information is protected. Records and reports. Compile record for all incidents involving sick or injured patients. Important safeguard against legal complications. So the organization need to have proper record, proper storage of recorded information, and the information need to be properly recorded. Court's perception of records. An action that was not recorded wasn't performed. That's how the court views it. That's how the legal system views it. If it wasn't recorded, it wasn't done. Incomplete or untidy reports are evidence of incomplete or inexpert emergency care. Make sure your reports are properly completed. Mandatory reporting requirements, so things that must be reported on. Most states have a reporting obligation if there's evidence of neglect or abuse of children or older people, domestic violence, injury during commission of a felony, drug-related injuries, childbirth, rape, animal bites, certain communicable diseases. Scene of a crime. Notify the dispatcher immediately if you believe a crime was committed at the scene. Your safety is going to be your number one priority. So your safety and the safety of your crew members. Provide care, but do not disturb the scene more than necessary. If there is any chance, attempt resuscitation. If death is obvious, cover the body and prevent its disturbance. Physical signs of death. Physical, a physician determines the cause of death. Signs can be presumptive or definitive. Excuse me. Excuse me a sec. Sorry about that. So signs can be presumptive or definitive. That is generally defined as the absence of circulatory and respiratory function. Many states also have brain death provisions. If the body is warm and intact, initiate emergency medical care. Hypothermia emergencies are the exception. Presumptive signs of death are generally adequate, particularly after severe or long-term illness, not in cases of sudden death. Presumptive signs of death include lack of a pulse, no eye movement, no blood pressure, cyanosis, lowered body temperature. Definitive signs of death include decapitation, dependent lividity, rigor mortis. Medical examiner cases. Medical examiner must be notified in cases of death at the scene, unknown cause of death, suicide, violent death, or death from accident, poisoning, suspicion of criminal act, death of a child. Organ donors. Organ donors express a wish to donate organs. Consent is voluntary, informed, evidenced by donor card or driver's license. Saving patient's life will always be your priority. Medical identification insignia. This can be a bracelet, necklace, or card indicating DNR order, allergies, diabetes, epilepsy, or other serious conditions. Check any jewelry patient may be wearing. And that would bring us to the end of this chapter.